Well, good afternoon, everyone. Again, my name is Adam Thierer at the Mercatus Center at George Mason University. I want to thank Glenn and Washington Legal Foundation for inviting me to be part of this excellent event. I'm going to make some off-the-cuff remarks based upon the substance of some recent law review articles I've recently done in the Harvard Journal of Law and Public Policy, the George Mason Law Review, and the Maine Law Review. These are all available online, but I figured today I would just come here and read them word for word. No. Okay, bad idea. So I love this topic. This is a terrifically interesting topic for me because I started out life 30 years ago studying philosophy. And, you know, when you study philosophy, the first thing you start by looking at is metaphysics, and eventually you get your way to ethics. And, of course, the question of what privacy rights we have or privacy obligations is really an intersection of these questions of metaphysics and ethics. So it's terrifically interesting to me, but it's also terrifically frustrating and difficult. And I spent a lot of time, like a lot of other people who've been involved in ethical philosophy and these issues, trying to struggle, you know, to find that perfect taxonomy of rights and sort of where our privacy fits into that conception of rights. And let me tell you something you all already know, which is that's damn difficult. It's perhaps even impossible. And what I've suggested in these law review articles is that because it's impossible, we may need to find a different way of addressing these practical concerns about privacy, even if we can't come to an answer about exactly what our privacy rights entail. So these law review articles are really inspired by work that I did as a much younger guy in the field of online child safety and free speech issues, some of which I did with a certain radical gentleman who bears a striking resemblance to the man who sits right here. He and I filed quite a few amicus briefs in the courts through the years and did other work together on free speech and online safety issues. And I'll tell you a quick story that's relevant to the question of privacy harms that comes from my experience in the field of online safety and free speech issues, which is many, many years ago, a scholar from Israel came to visit me because he had seen some work I had done, a law review article and some subsequent writing, and then he had seen an amicus brief that John and I had filed somewhere, I think in an appeals court. And he said, you know, Adam, you got to help me understand the American conception of online safety and free speech and how these things intersect, because it seems like you Americans really have kind of an extreme view of these things to the point where, you know, you have no laws governing hate speech and very limited rules governing like online access to pornography and things like this. He's like, can you bring it all down to a phrase for me of like how Americans think about online speech and online speech harms? And I said, yeah, I think I can with a nursery rhyme. Sticks and stones may break my bones, but words will never hurt me. That really describes almost perfectly the way we think about speech in the United States, that words don't do harm, that physical actions do. Now, that's not a perfect adaptation or explanation, rather, of American jurisprudence, but it's pretty darn close. The Supreme Court in this country, in so many cases, has basically said you can say or express yourself almost any way you want, sometimes going so far that I think I've held back defending things. I think there was the Stevens case that involved kitten-crushing videos, and there was a case on virtual child pornography. I think those are the ones I did not sign on to your briefs, John. I think I was out of those. But, you know, generally speaking, we go pretty far in America and say you've got to have a pretty high standard or test before you can restrain speech or expression. And for better or for worse, I'd like to suggest, and I do in my work, that that's largely our standard for privacy. That it is a sticks and stones kind of an approach, and words don't hurt kind of test, because generally speaking, with some notable exceptions that I'll get to in a second, we basically say that you're free to collect a lot of information about others, observe others, to report that information. A lot of that's because speech in this country and information flows in this country are governed, of course, by the First Amendment. So to the extent we want to talk about fair information principles, just to repeat a line that Eugene Volok's developed in some of his work, the ultimate fair information practice is the First Amendment. Information shall flow freely. So that creates a serious challenge for us because it very much limits what the law can and maybe should do to deal with what may be very legitimate privacy concerns. In the same way, the law already limits what we can do to address what some people may feel are very legitimate concerns about online access for children to pornography, or to all adults to hate speech, or to bullying, harassing speech. So how does this play out practically in the law? Well, for both online safety and for privacy, the way it plays out is we very narrowly target what we regard as the most sort of egregious forms of harm. that generally do involve threat to body or to property or to pocketbook. And we make those sort of a special class of safety or privacy rules. And we have a body of law that's developed around this. Again, quite limited in its scope and in its enforcement powers. And the rest of it, we basically don't say quite anything goes, but somewhere darn near close to it. Now, this is a very different conception of speech and privacy rights than, say, the Europeans or other countries and continents, right? But I want to suggest that it's not necessarily a bad one, that there are many benefits associated with that sort of being our philosophical baseline. And for many years, I struggled to figure out, well, how do you construct that same vision using, a conception of rights or whatever else? But practically speaking, I now think we're at the point, and I suggested this in 2 of these 3 law review articles, that even if we could come up with a perfect conception of what our privacy or safety rights look like, in certain cases we have to think about the fact that it's practically difficult and almost impossible to enforce those conceptions of rights in the modern information age. That the free flow of information, the sheer volume of information, its quicksilver nature and how fast it flows, make it increasingly difficult, if not impossible, for us to enforce sort of a top-down kind of control regime on speech, whether it's speech of an objectionable nature like pornography or of a privacy invasive nature. Now that's going to make a lot of people uncomfortable. The most interesting thing about these debates to me is that I've spent the first half of my life arguing with conservatives about how uncomfortable it makes them because of the fact this means like we're going to have a lot more porn and a lot more hate speech, a lot more other things. And now it's sort of folks on the left who are saying, but it means our personal information and our dignity is going to be abused by the nature of the fact that all this information is out there on us. Yeah, there's something to that. I agree with that because I happen to be an extraordinarily private person. For God's sakes, as a libertarian, my life philosophy can be summed up as leave me alone. And so, frankly, I try my damnedest to get everybody, not just the government, but corporations and everybody in between, just to stay out of my business, stay out of my life. And it's challenging. And there's times I want to assert my personal conception of privacy out there and say, hey, you should leave this out of it or leave this alone. But I know that's probably not only not right, but it's also probably not practical. So I think we have to be far more concrete about what we know to be very legitimate concerns about harms to self, property, pocketbook, things like this, and get concrete about that. And I think what you see in the FTC's test that's already been well explained here by Commissioner Alhausen and Catherine Armstrong, we see that sort of conception in the FDA's test of harm. It's a very limited one. And it basically says, the emotional stuff, no, that's not part of it. And we see that in American law as well. Now, let me get back to the exceptions, because there are exceptions. There are exceptions in the field of free speech. I mean, the whole field of defamation and libel, right? There are emotional harms there. Those are psychic harms, right? But they relate back to the fact that ultimately they can be monetizable in some way, or they can be concrete, and that it can degrade and devalue something else in your life. Your value is an employment or whatever else. But regardless of how you want to conceptualize that, it is extraordinarily limited. I mean, you got to prove actual malice. That's extraordinary, right? And you think about other limitations on, like, hate speech, almost none, or speech in public places. The proverbial can't shout fire in a crowded theater. And we have very limited time, place, and manner restrictions on speech. These are pretty good tests. They evolved over time. Well, we have those same tests and approach, I would argue, in the field of privacy law. And I think they're pretty good ones. I think if you look at how our torts have evolved, there are some rights that you can exercise based upon intrusion upon seclusion. And sometimes we even have targeted statutes, like peeping Tom statutes, that say you can't go take pictures of people in a state of undress, in a locker room or under bleachers or something. These evolved over time, and I'm all right with these. But for the most part, we haven't adopted this sort of overarching approach that basically says we have a clear idea of what privacy harm entails, and given the context, it will be applied in all of these different areas. I just think that's too murky, and it's not going to work. I think instead what we need to do, and again, to go back to the field of online safety and child safety concerns, is we need diverse solutions for a diverse citizenry. We need to think about a toolbox of approaches that we can utilize to try to solve these hard problems without resorting to any answer that involves, like, here's our overarching theory of privacy harms. Instead, we'll say, different people have different privacy issues and concerns. What can help solve those? Well, I'll borrow from the same toolbook that I've utilized in my past work on online safety, much of which I developed with John, which is that you start by utilizing educational-based approaches. You use things like digital literacy and digital citizenship. You have not only private actors and educators get behind that, you have the government get behind that. Talk to people about privacy concerns, privacy vulnerabilities. You use empowerment solutions is another second tool we have. You give people more and better tools to protect their privacy. Certainly we have a healthy debate going on in this country over encryption. We have an administration that's a little bit conflicted about these issues, to say the least. But stronger encryption is just one of many types of tools. There are many other types of safe browsers and other things like this that you can utilize. Industry self-regulation, codes of conduct, best practices. This is something that the administration, this current administration, has done a lot of good work on to develop these things. Joe Jerome's in the back of the room from Future of Privacy Forum. I always give these guys a lot of love because they develop some really interesting and excellent best practices for industry to follow in a wide variety of different contexts. I applaud that. Now, what beyond that? Because you say, well, that's not enough. Well, we've already heard a lot about Section 5. Section 5, in a very targeted way, goes after those concrete harms that everyone, at least in these states, can agree probably need to be actionable. I won't reiterate that except to say we have state actors and state laws. We also have AGs that are always willing to pounce, and we have a very healthy class action bar in this country. And then we, of course, have targeted laws. When all else fails, we say, okay, we really do need to narrow it down because this one is really bad. I don't quite understand how we got to that with video rental records, but we did. But we have it for financial and health, right? And we also have it for children with COPPA, for better or for worse. And I'm going to leave COPPA out of this for a second, but I've done a lot of work on COPPA. But the point is that we've narrowed it down. And again, you can go back to the idea that in an American conception of privacy, those have to do with harm to body, harm to health, harm to pocketbook. Easier to tether those privacy harms to harms that are traditionally more accepted. Now, beyond that, there needs to be something more said, and I'll wrap up on this point. I know I've run long. There needs to be a final word said about the importance of social adaptation and acclimation to new technology and culture. Because whether we're talking about online safety and speech, or whether we're talking about privacy, things change and people change. There are things said in our country, in the aisles of supermarkets today by average housewives, that would have been unthinkable in the 50s. And yet, that's the world we live in. Things are freely said in public spaces of a very vulgar and sometimes sensitive nature. There are likewise things shared in our country today, namely every day on Facebook, that would have been outrageous to share just a generation ago. Norms change. People change. Cultures change. We acclimate ourselves to new technologies and new developments, and our notion of harms change with it. I mean, all you have to do, and I've written about this a lot in my law review articles, is go back and read that famous 1890 piece on the right to privacy by Brandeis and Warren. To me, it's an extraordinary paper for many, many reasons. One of the most influential in the field of law. But it's extraordinarily in particular because of the way they wring their hands about the camera. And the fact that, oh my gosh, there's this thing now that can come out and take our image and take it from us, or take it from our family members without our permission, without our consent. What are we going to do about this? They said, what are we going to do? Well, we had our answer within a few short years as Americans. We were all going to buy one. We were all going to bring the camera into our lives and make it part of the American experience, right? It became an essential part of who we were as a culture. You flash forward 100 years. You think about the experience we had with new technologies, ranging from geolocation technologies or something like Gmail or things like this. Early on, a lot of these technologies, some privacy advocates said, we got to ban this. We got to stop this. This is incredibly invasive. Within a few short years, we're all like, well, this is pretty important. It serves a great function in my life, provides greater utility, does it at a good price, usually free. And so our norms and our societal values changed. And so that's the other reason I'm skeptical of efforts to have sort of let's have a clearly defined theory of privacy harm. I just don't think it's possible. Let's find constructive solutions to complex problems by working from the bottom up as opposed to creating sort of a top-down framework. Thank you.